Good morning, counsel.
If it please the court, I am Attorney Lee Alfieri, and I am here on behalf of the appellant, Smaland Beach Association, and 6 third-party defendants in the underlying litigation, 5 of whom are officers and directors of Smaland Beach Association, and the 6th, Carol Mahoney, being an adjoining property owner. The underlying facts of the case are that Smaland Beach Association, a nonprofit corporation, and Arthur and Patricia Genova own adjoining parcels of land in the vicinity of Island Pond in Cedarville, Massachusetts. The area of land that in front of their properties is a paper street of an old subdivision. On the other side of the road is Island Pond. That paper street, the paper street between the Genova property and Smaland's property in Island Pond, has been used for over 70 years as a community beach area. In 2004, Arthur and Patricia Genova, a number of disputes began to arise between the parties concerning the beach area in front of their respective properties, as well as claims and disputes concerning the parties' rights in their respective parcels. Genova is claiming that they have a building. There's no dispute about it. The building encroaches onto Smaland's lot. They dispute as to whether we had the right to make them remove them. There's a community path that runs behind the Genova cottage. We had a dispute as to whether or not there was an easement in that. Other disputes concerning whether they had extended their front yard into the layout of Crescent Road. As a result of those disputes, in January of 2005, I filed a complaint against the Arthur and Patricia Genova, 5 counts complaint concerning the various property disputes, the primary complaint always being the use of the community beach and the rights of the parties in that portion of Crescent Road that had been essentially incorporated into the beach. The Genovas filed a counterclaim, a 12-count counterclaim. 4 of the counts simply mirrored the property disputes that I had raised in the original complaint. There were another number of counterclaims that are not really relevant today, and a counterclaim against Smaland Beach Association alleging abusive process in bringing the complaint that I had filed, and a complaint against the 5 directors for third-party complaint against the 5 directors for abusive process and a breach of fiduciary duty. The litigation was somewhat complicated by the fact that in 2007 it was decided that the legal issues concerning who owned what in the Crescent Road were so thorny that there was a non-jury trial was undertaken before Judge McLaughlin in the summer of 2007, and he made a determination as to the state of the record title in Crescent Road, who owned what by virtue of deeds, and then we would adjudicate in the jury trial how those deeded rights may have changed or altered because of adverse or prescriptive uses of one party to another. Judge McLaughlin took 2 years to render a decision, and we were finally returned to an active status in 2009. We filed a joint pretrial conference report in October of 2009. At the time that was filed, the Genovas listed myself as a witness that they intended to call at the time of trial.
Let me ask you, here, the depositions in this case were taken
When?
In 2006?
They were all taken in 2005, 2006. All discovery was closed as of, I think there's even in the docket is a stipulation to that effect. All discovery closed August 22nd, 2006.
And so that was prior to the time of the non-jury trial in 2007?
Yes.
And nothing has been done subsequently by way of depositions or any further discovery?
No, all depositions.
In preparation?
The depositions ended in 2006.
So when the depositions, was there any indication prior to the jury scheduled trial, the scheduled jury trial, that you were going to be called as a witness?
We had filed a pretrial, we filed an original pretrial memo when
before
the bifurcation.
Yeah.
And they listed me as a witness at that time, and that would have been sometime in 2007, because we were bifurcated shortly thereafter.
Was there any effort to do any discovery with respect to your testimony, your proposed testimony?
They never undertook any discovery relative to my testimony.
Did you at any point then bring any kind of a motion in limine so that you could not be called as a witness? Was the issue as to whether or not you could continue to serve as counsel, in other words, joined before the 2007 trial?
No. I would say that I did not notice that I was listed as a witness when they did their original pretrial memo. The list of the pretrial memos are 50 pages long. The list of witnesses is 70. I just didn't notice. However, Judge McLaughlin, who tried the non-jury case, did notice it and made inquiry if they intended to call me at that trial, and they indicated no.
Okay.
So that it just was not, it didn't come up.
Now, with the deponents in 2006, were they all your clients?
Well, four of the deponents were my third-party defendants.
Well, let me tell you what I'm getting at here. Okay. There is the reason that one of the reasons Judge Chin gave for saying that you could no longer function as counsel was that you were somehow involved in the alteration of the errata sheets following depositions. And
I was involved in the preparation. The term alteration, I think, is a little...
All right, I'm sorry. I meant to say preparation of the errata sheets. And my question really goes to these errata sheets that are of concern rising out of depositions. The deponents, as to which these errata sheets are applicable, were they all your clients? 5
were my express clients. There were two other of the errata sheets that were presented to Judge Chin were from members of Smaland Beach Association. They are active members of Smaland Beach Association. Whether they are technically clients, I think, is a very gray area. As members, I represent the association. However, they came to me and requested that I assist them because they wanted to make changes. And I think that even if I was not technically their attorney, when they asked me to provide them with legal assistance and services, then I think I do become their attorney for that narrow purpose of helping them prepare an errata sheet.
And did Judge Chin have before him the errata sheets?
He had only before him the errata sheets. He had no deposition testimony.
And do we have those errata sheets anywhere in this record?
They're part of the, they are included in the appendix, I'm quite sure.
Do we have any of the depositions?
Pardon me?
Do we have any of the depositions?
The Genovas have now tried to introduce into the supplemental, in their supplemental appendix, all of the deposition testimony, but I strenuously object to that because none of those depositions testimony was ever presented to Judge Chin. All Judge Chin had were the errata sheets, and he had an excerpt, a 2-page excerpt from the deposition of Russell Johnson and a 2-page excerpt from the deposition of Louise Johnson, in which they were put in only to establish those two had undergone 2 days of testimony. So on the second day, the Genovas had undertaken some an inquiry of them concerning the errata sheets from their first day of testimony, and they produced just a two-page snippet in which they both testified that I helped them prepare the errata sheets. My office helped them prepare the errata sheets. I helped them put their thoughts into words, but that the errata sheet changes that they made were the product of their own desires and their own review.
And the explanations that were provided for these errata sheet changes were contained in the errata sheets?
Yes, they were proper errata sheets.
Well, but the explanation given was what, just
correct testimony, clarified testimony.
testimony? Change test. I mean, the errata sheets, at least, as an example, the deposition was, the answer was, in the first instance, no. On the errata sheet, yes. We use it to pass from Smaland Lane to the beach. In bandstand area, kids play in the water near the dock, and play on and around the dock and on the embankment. People used to use it as a bathing area, but I don't think many people bathe on the beach anymore. I mean, significantly different answers. Significantly different answers. And the reason given for the change was to clarify?
I haven't got it. If that's what it says, I haven't got that particular errata sheet right in front of me, Your Honor. And in all honesty, without a chance to look at the underlying deposition testimony and to put it into some kind of context, it's impossible to...
Well, the judge thought it was possible. I mean, he reviewed the errata sheets, and he says they raise serious questions of credibility, just based on looking at the errata sheets.
I understand. I understand that that is what he has said. I'm simply saying that I don't believe that one can say that by simply looking at the errata sheets. But more importantly, for purposes of disqualification and the reasoning that the court used, there's absolutely no finding anywhere or any basis to find that any particular errata sheet is on a matter that in fact is of any real significance in the trial, that is disputed, or that I intended to use those witnesses or their testimony to establish the fact at trial. All of that is surmise. All of that is conjecture. There's no finding. We listed over 70 witnesses. The Genovas, even in their conditional opposition, they filed a conditional opposition to my motion in limine to be precluded from calling a witness. They didn't file a motion for disqualification. That was all to Judge Chin the next day, sua sponte. In their even conditional, they acknowledged whether they will want to call me to examine me on the errata sheet will depend on how Smaland chooses to prove its case. There's no, you cannot assume that I intended to call any of those witnesses, or that the testimony that was subject to any errata sheet would have had played any part whatsoever in the trial. The Genovas took their depositions. I didn't take their depositions. They were not necessarily the witnesses that I intended to call at trial to prove any particular point that was in contention. There was no examination by Judge Chin to determine that.
Were any of these depositions of members of Smaland Beach Association?
Yes, they were. They were all members.
Well,
some were officers,
yeah,
and some are just members.
You weren't going to call any of these people?
Not when we get done, if you can understand that Judge Chin at the time of the hearing seriously, and to my great surprise, and caused a somewhat confusion, you can see it if you read the transcript, he determined that the major issues, the two major disputes between the parties, two of the major, I would say the major dispute, all of the disputes concerning the use of the beach area, Crescent Road, was not going to be tried to the jury. He took the position that had to go to yet another non-jury trial. He was not going to allow the trial on the issue of whether or not Smaland had an easement across the rear of the Genova's property, that was not going to be tried to the jury, that all that was going to be tried, and I will apologize to the court because I make reference to this in my brief, but I think I give incorrect cites to the page of the transcript. Judge Chin determined that the only count in plaintiff's complaint that was going to be tried was count 4, where we allege the cutting of a tree.
How about the counterclaims?
Pardon me?
And as to the counterclaims?
And as to the counterclaim, count 6 of the counterclaim, in which he claimed that somebody in Smaland entered their property and removed a granite survey marker and removed some large rocks. That's their claim. I
How
don't.
about the breach of fiduciary duty claim?
The breach of fiduciary duty claim, and I'm really sorry that time runs out because I need to address the breach of fiduciary duty claim, and I haven't. The breach of fiduciary duty claim, the judge made an absolutely critical error in the breach of fiduciary claim because he made no examination to determine whether or not they had a viable breach of fiduciary claim.
My question is, was that to be tried in the jury trial? Was there any statement?
Yes, he decided that it would be tried in the jury trial, but then did not take any examination of whether or not they had a viable breach of fiduciary claim, what was the nature of that claim, and whether or not, in fact, the third-party defendants would have any need to raise the abuse, the advice of counsel defense in defense of the breach of fiduciary duty claim. And he, again, engaged in an endless speculation. I had presented to him, which he did not consider, a motion in limine to strike the breach of fiduciary claim or to severely limit it, based on the fact that at law there is no fiduciary duty in existence. It's a non-existent claim, and in point of fact, what the breach of fiduciary duty claim was just a rewrapping of the abuse of process claim. And Judge Chin specifically ruled that the abuse of process claim could not be tried until all litigation was over. The breach of fiduciary duty, if there is a fiduciary duty, which I assert there was not, likewise, it was just the same stuff. They
We're
breached
going to have
their
to
duty.
leave it there, counsel. Your
Okay.
time is up. Thank you.
And I thank you for the slight extension. I appreciate it.
May it please the Court, my name is Robert Kraus for Arthur F. Genova and Patricia A. Genova. The issue before the Court clearly is whether Attorney Alfieri should testify and whether it was right for Judge Chin to disqualify him because of that testimony. Judge Chin stated in his decision after a lengthy hearing on December 3, 2009, his testimony is not going to be on trivial matter. It is going to be regarding a defense of his client to 2 counts of a complaint of your counterclaim. Also, I think it would be very prejudicial to the defendants, the appellees, my clients, to not allow you to call Mr. Alfieri because, from what I see of the errata sheets, highly unusual.
So explain how that would work at trial. How would you call Mr. Alfieri? You've got a witness on the stand. They've testified. Presumably you've cross-examined them on their deposition testimony, their errata sheets. How is Mr. Alfieri?
For instance, Elsa Anderson, who is not one of Attorney Alfieri's clients, a critical witness because she has history going back to the 40s, 50s, and 60s.
90-something-year-old woman?
At about this time she is. At the time of her affidavit, which is critical in this case, May 23, 2005, she was in her 80s. Her brother, Eddie Olson, also did, or Gustav Olson, also did an affidavit of that very same date. He's now deceased. Both non-clients. Presumably Elsa Anderson, God willing, is alive and she testifies. And then the question would be, as we took her second deposition, questions about her errata sheets. In her second deposition, she states, I have no memory of creating my errata sheets. I have no memory of creating the affidavit in May of 2005. Attorney Alfieri testified in front of Judge Chin and indicated there was, due to some medical conditions, Ms. Olson has absolutely no memory of that time period. Even under the Steinert case and that theory of trying to avoid bringing a counsel as witness, there is no one else to testify.
So you had deposed her for the second time, what, in 2006?
Yes, Your Honor.
You never asked to depose Mr. Alfieri.
No, Your Honor, our position is that the calling of Attorney Alfieri to explain the nature of the change in the deposition and the creation of the affidavit would be a trial issue.
But before you asked to disqualify, I guess you didn't ask, before somebody is disqualified, is it not appropriate to have that attorney deposed so that the judge can look to see precisely what that person's testimony would be and whether or not it fits within in terms of balancing the equities here? Would that not be something that a judge is obligated to do or that you should do to protect Mr. Alfieri's clients from losing its attorney?
Your Honor, the argument in front of Judge Chin on December 3, 2009 addressed this issue. As Attorney Alfieri admitted, he knew in 2005 because of the defense's...
Okay, try my question about whether or not you should have then deposed. If his testimony was so critical, should you not have deposed him, and should the judge not have had before him his deposition testimony so he could balance the equities?
I don't believe so, Your Honor, because the fact that Elsa Anderson, and let's just deal with her, Elsa Anderson testified that Attorney Alfieri helped her prepare, in his words or her words, the errata sheet. The clear testimony would be, yes, I helped her prepare it. As Attorney Alfieri just stated here in front of you, quote, they wanted to change their positions. They wanted to alter their deposition sworn testimony and to create the affidavit. There's no burden on the Genovas to determine what Attorney Alfieri's role is in that, other than being able to use it for cross-examination and credibility purposes. It's for Attorney Alfieri to determine under the Code of Professional Ethics and the disciplinary rules whether he, in fact, would be called as a witness. In May of 2006, we listed him as the first witness in our first pretrial memo. In May of 2007, May 30th, I think to be precise, May 30th, 2007, Judge McLaughlin, now retired, inquired as to whether we intended to call Attorney Alfieri. He knew it was going to be issued. And then again in October, we listed him as a witness because of the creation of these affidavits and the errata sheets. If you look at the affidavits of Mr. Olson and Ms. Anderson, each 7 to 8 pages. Ms. Olson's is 44 detailed paragraphs. Mr. Olson's is 51 detailed paragraphs, with a clarity of memory and a distinction of fact that is unmatched in their deposition testimony. That is fair game for us at the time of trial.
Do you have to make a showing, though, that somehow Mr. Alfieri's testimony is going to be prejudicial to his client?
Your Honor, Justice Lenz, all we did was seek to list him as...
I know that, but I'm saying in order for the disqualification to stick, doesn't it have to be some kind of a showing that Mr. Alfieri's testimony is really necessary and that it's not just to rehabilitate his clients, because that wouldn't help you. And that wouldn't be a decision, it seems to me, that would compel him to recuse himself. Don't you have to make a showing of some kind that Mr. Alfieri's testimony could be helpful to your clients? And how do you know that?
Well, Justice Lenz, to answer that, again, going back to the hearing that was before Judge Chin on December 3, 2009, Judge Chin inquired into that precise point, particularly as it involves Elsa Anderson, again, a critical witness because she has memory of a time period where the Smaland Beach Association claimed they had certain rights to the property, as Attorney Alfieri indicated. Judge Chin elicited from Attorney Alfieri that Ms. Olson had no memory.
That's now.
No memory of creating the errata sheet and the affidavit. The only person who could testify as to how they came into being and the source...
Didn't you examine her on a second day?
I did.
And what did she say at the time? That she didn't remember what she said yesterday or the first time she was
She said that she did not have distinct memory of creating the affidavit and the errata sheet. I think her quote was something to the effect that He wrote it up better language than what you know I had, and it's in the supplemental appendix. But she had no distinct memory other than in her errata sheet. Her deposition testimony was unclear as to how the affidavit came into effect. The errata sheet altered that so that she had a clarity of knowledge. She had a memory of meeting with Attorney Alfieri. She had a memory of talking to her brother, of reviewing her brother's affidavit. That wasn't apparent in her deposition.
But it was apparent the second day.
It was apparent from her errata sheet.
That's what I mean. Okay.
Yes.
Errata sheet, oh, I see. But you examined her about the errata sheet on the second day.
I did. And again, her memory is that somehow, some way, Attorney Alfieri assisted her.
Okay. Could you tell me how Ms. Anderson's testimony is going to be relevant to the matters that would be tried at the jury trial, either the cutting of the trees, the removal of the marker, or the breach of fiduciary duty claim?
Your Honor, her testimony may not be imperative on those issues at that moment in time, but there are still issues left to be tried. Literally, what's Judge Chin...
Not at the jury trial.
Potentially in a jury trial, Your Honor.
No, not at this coming one, which would be involving these claims.
That is correct. Yes.
And so those are the only Ms. Anderson's the only non-client, right?
No, I presume, because Mr. Olson's testimony, his affidavit is so important, and his testimony from the transcript is so important, because he likewise goes back to an early time.
Now, he's not the one who's deceased.
He is deceased.
Okay.
So how could you use that, though?
If, in fact, my brother, under the dead man, if he tried to introduce somehow, some way, his deposition testimony, because he's unavailable under the rules, his deposition transcript could come in. Now we come into the situation where a dead man is testifying from an affidavit, from a deposition transcript, and from an errata sheet. Again, it's important, and we included them in the supplemental appendix, to read the words of the deponent, as opposed to the words of the errata sheet. There's as you know, there's a line of cases from different jurisdictions as to the ability under 30E to change an errata sheet. As Greenway indicated in the Western District of Louisiana, it's not a take-home exam. You don't have an unfettered ability to alter testimony that is generated on a face-to-face crucible of examination in a deposition.
Isn't the answer to either move to exclude the errata sheet or to move to extend the deposition, to reopen the deposition?
Your Honor, our trial tactics were to use the errata sheets in order to impeach the credibility.
Why didn't you give those depositions to Judge Chin?
Your Honor, the depositions, the expanded appendix that we provided were included in the motion for reconsideration that was brought by our brother. And the depositions had been used. Remember, the case has been going on since 2004, 2005. It's been used in a variety of different motions for summary judgment, preliminary injunctions, other. Judge Chin indicated very clearly that he was knowledgeable about the record. He knew what the errata sheet said. And he was the second judge to indicate that they were highly unusual, as Judge McLaughlin indicated in May 30th, 2007.
Let me ask you, though, I mean, there's no way, is there, that if we were talking about clients' errata sheets, that the testimony of Mr. Alfieri could be used?
We reserve the rights in our brief, Your Honor, and I know that Attorney Alfieri has raised the issue of protection and Judge Chin raised it, but we're not sure that we agree with the judge. If the question comes while someone is testifying who has an extensive errata sheet, for instance, Mark Johnson, give you a perfect example. In his deposition, he indicates that he doesn't remember a doc and that he only came back in 1971, and he doesn't remember it, or 91, and he doesn't remember it in the 60s and 70s. His errata sheets, lo and behold, he's had an epiphany. He remembers it distinctly that there was a doc and that area was used, quote, by Smaland Association. Now the issue is, on examination, who prepared the errata sheet? Did you use assistance of counsel? There's a gray line I think we would be pushing to determine, in fact, how his recollection was so revived as to have a new testimony, because it constitutes new testimony. There's no new evidence.
They ask him about this.
Yeah, but at that certain point, Justice, if in fact the question is asked, were you assisted in the preparation of the errata sheet? Presumably the answer will be yes, because again, the comparison of language, that his counsel assisted him. In fact, I think in
But my point is really going toward, what could you ask Mr. Alfieri about that? Because he's the one who's being disqualified in order that he can testify. And I'm having some difficulty understanding what it is Mr. Alfieri could testify to without impinging on the privilege.
Justice Lanks, the boundary the line that we'd be pushing is, whose language was it? Where did these ideas come? Why is that so much like the errata sheet for Russell Johnson or Louise Johnson or Marlene Lauderhand or others whose testimony through the errata sheets is so similarly stated?
But wouldn't you have to get into the content of the communication between attorney and client in order to be able to make that, to pose those kinds of questions?
Not necessarily, Justice. If Mark Johnson, for instance, was asked about his errata sheet, and that was very similar to the errata sheet change for Marlene Lauderhand or for Jerry Bossi or other of the Smaland members, such that it was a consistent line of threaded testimony, inconsistent with the deposition, with all of those individuals, but threaded to a common notion, a common fact that supports
I'm not understanding what you just said.
If the errata sheets, for instance, on the dock issue, the errata sheets changed the dock issue on Mark Johnson's testimony, Elsa Anderson's testimony, Eddie Olson's testimony, Russell Johnson's testimony. The errata sheets all changed that particular fact so that they all have a memory. They all have a memory of a dock being there in the 60s. The question to Attorney Alfieri is, did you have any part in crafting the response so that a particular date was provided? We believe it's fair game because of the nature of these errata sheets. Your Honor, this is not one or two errata sheets. I understand that Mass Rules of Civil Procedure 30 allows both substance and form changes. But there is a consistent pattern that's been generated by the review of these errata sheets that tends to argue that, in fact, these errata sheets were a trial tactic. A deposition is to get at the truth, not to win at any cost. That's the distinction that we bring. We only want to bring Attorney Alfieri in as a witness. We didn't move to disqualify him. We didn't move to hurt him. That wasn't the issue. And an attorney testifying before a court is not a fun matter, and it's not something that we took any great pleasure in requesting, and that's why we filed conditional. Because as in the Steinert case, and I think, Justice Link, you participated in that decision in the appeals court, we have to take all available opportunities to avoid that. Well, with Elsa Anderson, Gustav Olson's dead. There's nobody else who could testify. Elsa Anderson is not his witness. We need that testimony because of the dramatic change of her testimony. Same thing with Russell Johnson and many of these others on the third-party claims on the defensive counsel advice, because during those depositions, there was no objection raised by Attorney Alfieri to us inquiring into the errata sheets and other changes. We believe it's fair game. We're only seeking to protect the Genova's rights in this claim so that they can present to the jury a fair presentation of what the truth is. And those, whether you use the sham affidavit theories or the credibility issues, those errata sheets create such a lapse of confidence in the honesty of the testimony that the jury must hear it, because otherwise our clients are prejudiced. If there are no further questions, I'll
actually, if I may, the breach of fiduciary duty claim. What is that claim?
The third-party defendants, the action was
the short version, please. Just give me the short version. What's the essence of that breach of fiduciary duty claim?
That the complaint was brought before proper proceedings before the body bringing it. That is that these.
I'm sorry.
That the decision to bring the litigation was done by a few individuals and not the Smaland Beach Association against its own members, the Genovas, who were members at that time.
So that it was a breach of fiduciary duty to bring a claim against one of its members.
Without proper
procedures for endorsement of the complaint and the review of the facts.
And would that depend upon whether or not the claims were frivolous, or if the claims were justified, could that claim prevail?
We believe so, Your Honor. We believe that we certainly have a right to inquire into them because the way that the case was postured was a personal dispute against the Genovas after they asserted some rights in land that they believe they own and, in fact, that they have found to own. They won that case. They won that decision. They owned it. But the Smaland Beach Association in total didn't like that, didn't like their protection of the Genova's property that they had protected and improved over a 30-year period of being a member of this beach association.
All right, thank you, sir.
Thank you.
We'll take a
Thank you.
brief recess.